Well, welcome everyone to another team talk, and this is a big one. The Employment Rights Bill and the Umbrella Regulation updates are some of the biggest challenges and changes that have been in the recruitment space for many a year. And I'm really pleased to invite the principal lawyer and partner of team, Paul Chamberlain from JMW. You've been with us, Paul, for way longer than me, I think, haven't you?
I think it's probably 25 or 26 years now, Simon. Yeah, long time.
I'm just a new kid on the block. So thank you for joining us. Your constant support and direction have been such a backup to our members. I'm really pleased we've got a lot of members on board today, and some players from the outside of team. But you're very welcome too as guests. Paul, I'm going to hand over to you on this pretty challenging subject with some still moving feasts, aren't there, attached to this?
I think that's right, and a few hot off the press developments, cool. Which I'll be glad to impart as we get going. So just to make the point, Simon, if people are attending this expecting a sort of walk through all of the provisions, that's not what this is designed for. This is more of an update. So you'll have heard my first presentation on this topic, and what we decided to do with team is to keep people updated. So this is really where I see the direction of travel over the next 12, 18, 24 months, and some very recent developments. So I have my trusted colleague, Catherine, who is going to manipulate the slides for me, I hope.
Of course she will. I'll duck out and leave the show to you, and I'll come back and I'll manage some Q&A. Please use comments, folks, for your any questions you've got for Paul, and we'll have a Q&A session at the end, which we'll run through. Thank you very much. Take it away.
Thank you very much indeed, and thanks, Catherine, for that. So just a reminder then, for anyone who's been hiding for the last 12 months or so, the Employment Rights Bill was published late last year. The government said that they would introduce a bill within 100 days of coming into office, and that's exactly what they did. And since then, the bill has been ploughing its way through the parliamentary process. And I think it might be sensible to move on to the next slide, Catherine, because I can update people as to where it's got to. So just before the summer, the bill might get royal assent before the summer recess. It didn't, but it did find its way towards the end of its process in the House of Lords. Parliament then broke for summer and then came back, and on the 3rd of September, the House of Lords had the third reading of the bill. Now, the third reading is really just a procedural point in the process where drafting errors can be tidied up. Small changes are made to make sure that what the government's intended will be effective and workable, and hopefully any loopholes are closed. And that's exactly what happened. But the Lords also took the opportunity to vote on a number of amendments, and those amendments will now go back to the Commons. It's expected that there will be a further Commons debate, I think next week, on all of this. So we're not far away from royal assent, and one of the slides a little bit later I'll take you to, which sets out the roadmap that the government have published as to when the provisions will come in. Because back in the day, Acts of Parliament would be given royal assent and then they would be immediately in force. But the fashion over the last 15 to 20 years has very much been to implement the provisions in stages. So when it gets royal assent, yes, it will be an act of Parliament, it will be a statute, it will be an effective piece of legislation. But a number of the provisions will only come into force later on as part of the government's roadmap. So let me get back on track. The third reading in the Lords and a number of amendments that were passed, and they will now fall to be determined by the House of Commons. The first amendment was an amendment in relation to what you might have heard called fire and rehire. I'm not entirely convinced that's ever been the right name for it, but in very broad terms, the government's proposal was if someone was dismissed for refusing to accept a change to their terms and conditions of employment, then that dismissal would be automatically unfair and they'd be able to bring a claim in the employment tribunal. The worry that a lot of people expressed as a consequence of that stated policy was that the government weren't differentiating between serious changes or changes to important terms and changes to very minor terms, and therefore employers were going to be hung, drawn and quartered where they'd suggested a relatively minor change to someone's contract. The individual refused that change. The employer then decided they got no alternative but to dismiss that employee, and that employee would then bring an employment tribunal claim. So the Lords debated that as a matter of principle, and what they came up with was an amendment that effectively only allows that unfair dismissal claim to be brought where the proposed contract changes relate to pay, pensions, hours of work, or holiday entitlement. So if you think about it, those four things are probably the most important four things in the employment relationship between an employer and its employees. And therefore, if an employer wants to unilaterally change any of those terms and the employer refuses that change and the employer then dismisses the employee, it'll be in those circumstances and those circumstances only where the individual then has the right to bring a claim of automatically unfair dismissal in the employment tribunal. That's the proposal from the House of Lords. My understanding is that whilst that makes sense, it isn't a government-sponsored change or amendment, and therefore it's probably unlikely to see the light of day. The second amendment that the Lords have proposed relates to guaranteed hours contracts, and of course it's very important we mention guaranteed hours contracts because in this sector this is probably one of the most important changes to the law that's being proposed by the government in the bill. Now, at the moment, the provision as it stands requires the end user client, the hirer of the employment business, to make an offer of a guaranteed hours contract to any agency worker who qualifies. The suggestion at the moment is that there'll be a qualifying period of 12 weeks. So the worker will get the protection of these provisions after 12 weeks. And the guaranteed hours contract that they will be entitled to receive an offer of will be based on the hours that they've worked in the previous 12 weeks. So in other words, you add up all the hours worked, divide by 12, and that will give you a weekly figure. That weekly figure will be the weekly guaranteed hours that the end user client will be obliged to offer the worker. And I'm paraphrasing what is a fairly complicated provision, but that's it in a nutshell. Now, the Lords have said they would prefer it if the emphasis shifted, and instead of it being an obligation on the end user to offer a contract where the worker qualifies, it will be a right given to the worker to request a guaranteed hours contract if they want it. Now, I think that more sensibly mirrors the reality of life, because whilst I know a lot of people were getting very agitated about the possibility of end user clients being forced to offer guaranteed hours contracts to 0 hours contract workers, my view is that the majority of workers in this sector would simply turn that offer down. Thank you very much for making that offer, but we regard ourselves as flexible workers. We don't want a contract that gives us guaranteed hours. We want the ability to flex as and when. And of course, that's why largely end users are using agency workers in the first place, because they want to be able to flex up and down. So my take on it was that I thought there would probably be a very low uptake of workers accepting an offer of a guaranteed hours contract. I think the Lords have taken a similar view, and what they've said is after the qualifying period, it will be sensible to give the worker the right to ask for the guaranteed hours contract if they want it. If they don't want it, they won't make a request. If they do want it, they will. And in those circumstances, there'll be an obligation on the end user to make sure that one of those contracts is put in place. So will that see the light of day? It strikes me probably not, even though it's extremely sensible. And the reason it probably won't is because what the government is saying in relation to these amendments proposed by the Lords, they're saying that they detract from manifesto commitments that they made around the election, and it wouldn't be appropriate for them to water down the provisions further. They need to comply, they need to abide by their manifesto commitments, and these amendments don't allow them to do that. And then the big one is the third one on the screen. You will all be familiar, if you've seen any of these webinars previously, if you've attended any of my presentations on the topic, that one of the big changes under the Employment Rights Bill is to give employees the right to bring an unfair dismissal claim without having to qualify by working continuously for 2 years. That's the current requirement. You can only bring an ordinary unfair dismissal claim if you've got continuous service with the same employer for 2 years or more. If you have less than 2 years service, that claim isn't available to you unless there are certain narrowly defined specific circumstances. The government's proposal was to get rid of that qualifying period. So in other words, to give all employees the right to bring a claim of unfair dismissal as soon as they started in employment. A lot of employers have pushed back very hard on that, and the government have tried to ameliorate those concerns. Sort of statutory probationary period within which it will be a little bit easier to dismiss people, but nonetheless, individual workers, employees will have the right to bring a claim of unfair dismissal, because a statutory probationary period is not the same as abolishing. Sorry, is not a shorter qualifying period by the back door. The House of Lords took the view that the slightly more pragmatic approach would be to have a qualifying period for unfair dismissal, and they were proposing 6 months. That's the amendment that they have proposed, and which the Commons will now consider. Again, do I think it's likely to see the light of day? The answer is no. The government have been very, very clear on ensuring that unfair dismissal protection is afforded as a day one right. So I think it's extremely unlikely that what I regard as a sensible amendment, that will be accepted by the Labour Party and therefore by its majority in the Commons. Now, I prepared that slide before what happened on the 5th of September, and I do think there's a possibility that Angela Rayner resigning might bring into sharp focus some of the provisions in the bill. Do I think Angela Rayner resigning will mean the bill falls away? Absolutely not. Do I think Angela Rayner resigning will change the government's intention to legislate in this area? Absolutely not. But do I think Angela Rayner, who was one of the main proponents of the bill, Do I think her resigning might change the timetable? Well, I think there is a possibility that the timetable might change. So some provisions might be pushed back, but I really don't think any of the provisions are going to fall away. And interestingly, yesterday, you'll have seen some of the news around the Trade Union Congress and them demanding of the government that they should follow through with their commitment to protect workers by implementing this bill. There was a press release made by the government yesterday in response to what the TUC were saying, and I'll read it out to you here. The government said, quotes, "We're committed to delivering the biggest upgrade to workers' rights in a generation." The new Business and Trade Secretary held calls over the weekend where he confirmed a laser focus to delivering and implementing the legislation and doubling down on growth. "We will always work with business for the implementation. We are a pro-business government. We will continue to engage as the bill progresses through Parliament. That includes overturning the amendments in the Lords. The two work hand in hand, they say, a strong economy and workforce. This will be good for business and good for growth." Now, I don't think there's any ambiguity about that press release or that statement. They are saying very clearly to the TUC and anyone else who wants to hear it that they intend to press on. There's no mention in here, of course, around the timetable, but there's a very clear commitment to abide by the broad provisions set out in the bill. But if I can just focus on one very small section of the release, they say in the release that includes overturning the amendments in the Lords. So the amendments on this slide that I mentioned, I already took the view we're probably not going to see the light of day. But interestingly, and I don't know whether this is just an error, there were a number of amendments that were made to the bill which were government-sponsored amendments. So if you follow that through to its logical conclusion, the government saying they intend to overturn amendments in the Lords means that they're intending to overturn amendments which were government-sponsored. Now, I think that is personally, I think that's just an error. I can't imagine they will overturn their own amendments. They'll probably overturn everybody else's, but not their own. So probably an error in the release, but that's a detailed point. The point to make here is they are stressing, in light of some criticisms yesterday from the trade union movement, they're stressing their intention to push through with these changes. So there's the possibility we might have a little bit of legislative ping pong between the House of Commons and the House of Lords to ensure that the House of Lords amendments don't pass. But if the House of Lords want to have another look at it, they're entitled to do that. And then we'll get royal assent. When we'll get royal assent, no one's entirely sure, but I will be surprised if it's not before Christmas, and it may well be shortly after the party conference season. Okay, so that first slide took rather a long time to get through, and we're 19 minutes in, so I need to pick up the pace a little bit. So Catherine, could you move on to the next slide for me, please? So what I thought I'd do, having sort of brought you up to speed with where we're at now and the hot off the press news from yesterday, I'll just remind you about what provisions in the bill I think are important for this sector, for the recruitment sector. I've already touched on 3 of these, but just as a reminder, the 0 hours contracts provisions, Angela Rayner said originally she wanted to abolish 0 hours contracts altogether. She realised that probably wasn't the best policy statement she'd ever made. So she rode back on that slightly and said, no, I'm going to leave 0 hours contracts in place, but what I'm going to do is tackle exploitative 0 hours contracts. No real definition of what she meant by exploitative, but when you look at the provisions relating to 0 hours contracts, you'll see exactly what she is suggesting might be examples of exploitation. So the biggest change in this area, as I've said already, is to offer a guaranteed hours contract to anyone who is on a 0 hours contract after they've been working for a minimum period. The other way of tackling exploitation in this area is to try and legislate against last minute notice being given of a shift being cancelled or modified. And there are provisions in the bill which will require reasonable notice if a shift is going to be cancelled or if it's going to be modified, and there'll be penalties, effectively penalties, if those obligations aren't complied with. So the provisions as they stand at the moment are moving in favour of guaranteed hours being offered. Whether that then becomes an obligation on the worker or a right for the worker to ask for a guaranteed hours contract, as opposed to the end user client offering a guaranteed hours contract, well, we'll have to wait and see, but I'm not optimistic. And the other element around 0 hours contracts is to ensure that reasonable notice is given if a shift is going to be cancelled or modified. If those rights are breached, by the way, then there'll be employment tribunal cases. One of the big concerns that I've got as an employment lawyer who works in the system with employment tribunals every day of the week is that the employment tribunal system at the moment is significantly overburdened. They have too many cases, they have not enough clerks, and certainly not enough judges. And if this bill becomes law and it results in an increase in employment tribunals, I think that will only make the system worse without further resources to try and improve the speed with which cases are dealt with. So that's an aside, but it's a point that's made generally in relation to all of these changes. Unfair dismissal I've already touched on. The current proposal, subject to the Lord's amendment that we've discussed, the current proposal is to give people unfair dismissal protection from day one, so removing the 2-year qualification period and then bringing in a statutory probationary period as a bit of a sop to employers. Statutory sick pay we haven't talked about, but statutory sick pay is going to change quite dramatically from April of next year. The lower earnings limit is going to be removed, which is going to bring probably around about 1.3 million workers into scope for statutory sick pay. So people who've been excluded from it to date because they earn less than the lower earnings limit, they'll be brought into the scheme. So that's the first big change. The second big change, and for those of you who operate statutory sick pay, you'll know all about this. Statutory sick pay is only payable from the 4th day of absence. So there are what are called 3 waiting days before the worker is entitled to receive any statutory sick pay at all. The government's view is that that is not fair, and the government intends to abolish the 3 waiting day provision, which means that everybody who is otherwise entitled to statutory sick pay will get it from the first day of their absence due to ill health. Fire and rehire, we've talked about. The Lord's proposal, as I've said, is to limit this right to bring an automatically unfair dismissal claim where the change imposed by the employer is in relation to a serious or fundamental term in the contract, but it may well be that we don't get there on that. But at the moment, the proposal is any change which results in someone being dismissed because they refuse to accept it, that would give them an entitlement to bring a claim in the employment tribunal. And the final item on this slide is tribunal time limits. Those of you who've had the misfortune to be involved in an employment tribunal will know that most claims have to be brought by the worker or the employee within 3 months of the act that they're complaining of. So the easiest example is if they want to bring an unfair dismissal claim, they've got to bring a claim within 3 months of the date they were dismissed. It's possible, depending on ACAS conciliation, possible to have that period extended by around a month or so. So in some circumstances, limitation can be 4 months, but the primary limitation period is 3 months. The government's proposal is that that isn't fair, and that workers, employees should have longer to bring their claims. and they're proposing, therefore, to extend those time limits to bring claims from 3 months to 6 months. And that may be a little longer than 6 months again if you take into account the ACAS pre-conciliation process. So, as I said right at the start, I'm not proposing to go through everything in the bill today because that's already happened. There's already been a session on it, but I just thought it was sensible to remind people about what I think are going to be the main changes and the main areas of concern for the recruitment sector. So, if we move on to the next slide, please, Catherine. I mentioned at the start that the government had published a roadmap, and this was really helpful because a lot of employment lawyers like me could see the broad framework of the bill, but we didn't really have any indication as to what the government proposed in terms of implementation. When were they proposing to implement certain provisions? So what they've done in the document they've published, and bear in mind this was before Angela Rayner resigned, and if there's any area where I think this might flex, or the provisions might flex, it's here. I think there is a possibility, but I can't say any more than that. I don't have any inside track. There's a possibility that this roadmap might flex a little bit, that some of these dates might be rather more elastic. If you look at the roadmap as it's been published, you'll see that there are some proposed implementations in April 2026, statutory sick pay, which I've already touched upon. The Fair Work Agency is also going to be established in April 2026. The Fair Work Agency will effectively be a single enforcement body that brings in enforcement from other bodies like the Gangmaster and Labour Abuse Authority, like the Employment Agency Standards Inspectorate, and like HMRC, where HMRC currently are responsible for policing payment of the national minimum wage. I and most other people, I think this is a really good idea to bring everything under one roof. But again, it's subject to resourcing. If the Fair Work Agency isn't properly resourced, then it could end up being a bit of a damp squib. But it has very wide-ranging powers, and it will be formally established, as the roadmap currently suggests, in April of 2026. I'm not going to touch on this in any great detail, but I'll just mention that one of the other things that's going to happen in April 2026 is there are going to be some changes to the Collective Redundancy Protective Award, where the maximum period is going to be doubled. That's a technical legal change, but nonetheless, April 2026 is when it's proposed. And statutory sick pay, we've already mentioned. The one thing that's not on here, because it actually isn't part of the Employment Rights Bill, despite what people have suggested to me recently, but those of you who are either umbrella businesses or who work with umbrella businesses will know that there is a proposed change to the tax regime where umbrellas are involved in the supply chain. Currently, it's the umbrella that's responsible for making appropriate deductions for tax and national insurance contributions and accounting to the revenue for those payments. The government have looked at that and have recognised that there are some umbrellas who have not operated lawfully or compliantly in that area. And what the government's proposing is that the liability for making those payments and ensuring that the revenue get the money they're entitled to, the liability for that will be joint and several, as between the umbrella and the agency. And indeed, in some circumstances, further up the chain, there's the possibility that the client might also be on the hook. That's not a change that's proposed as part of the Employment Rights Bill. It's a separate fiscal change, but it is worthwhile mentioning that the proposal there is that those changes will be effective from April 2026. In or around October of 2026, we're going to see the law change in relation to fire and rehire, which is what I've already touched upon, unilateral changes to contracts which result in people refusing those changes and then being dismissed. That law will come into force in October 2026. And the change to employment tribunal time limits, That's also proposed to be effective as from October 2026. So you can see the bill gets passed in late 2025. A number of the provisions will only be in force by the end of 2026. And as you'll see from the final column on the slide, we're even into 2027, April or October or some other time in 2027 when a number of other provisions are going to come into force. So we'll have had the bill proposed in 2024 and a number of very important provisions only implemented or effective around 3 years later in 2027. So you'll see from the list that I've put on the slide, the first area it involves umbrella companies. There is going to be regulation of umbrella companies. The government have decided that umbrella companies should be brought within the definition of employment business under the Employment Agencies Act and the conduct regulations. There'll be some consultation around what that should look like, but there will then be no doubt that umbrellas are covered by the conduct regulations and the regulatory framework that employment agencies and employment businesses are currently subject to, and that will increase the administrative burden on umbrellas as from 2027. There are also going to be some changes to collective redundancy laws in 2027. The government are promising some changes to the law around flexible working, again subject to consultation. And then 2027 will be when we see the changes I've outlined in relation to 0 hours contracts and exploitative issues pertaining to 0 hours contracts, the implementation of the guaranteed hours regime, whatever that looks like. That's going to be at some point in 2027. And then finally, day one rights around unfair dismissal. We're looking at 2027 for the implementation of those. Now, what I'd suggest is, whilst this roadmap's really useful, it might be subject to change as a consequence of Angela Rayner's departure from government late last week. But even if it isn't, I wouldn't be inclined to put the roadmap in the drawer and forget about it for 12 to 18 months. The roadmap's very useful because it gives you a clear indication as to when these provisions are going to take effect. So it would be really sensible for you to be thinking ahead and planning how you're going to tackle each of these changes as we get to that point. So don't think that things in 2027 are an age away. 2027 will be here before we know it. And if you haven't done any preparation or given any thought to how these provisions might impact your recruitment processes, your business generally, your relationship with your clients, which is obviously extremely important, because these provisions don't apply just to agencies. And if I've given that impression, then I certainly shouldn't have done that. These provisions apply across the board. They apply to all employers, and your clients are employers, and they will be affected by these provisions as well as you. What a lot of forward-thinking agencies have already started to do is to talk with their clients about the provisions in the Employment Rights Bill, and certainly those who use umbrella companies have started to talk to their clients about the changes which are imminent in April of next year. A great opportunity to get much closer to your clients, a great opportunity to add value, and a great opportunity to show your clients that you're on their side. So these provisions are certainly problematic, but they really do give you an opportunity to bolster the existing relationships you've got with your clients, to strengthen them, and really work in partnership with clients to make sure that they and you are protected. So I think we'll probably need to move on to the next slide. Thanks, Catherine. Not much law on this slide, but I think it's just worthwhile to put it into context. Why now? Well, why are we seeing more regulation around agencies and umbrellas. Well, we've seen a growth in agency work over the last 10 years or so. We've seen a significant increase in the use of umbrellas and different types of umbrella models. And as a result, the government have seen that there have been some gaps, that there are some gaps. The gaps have been exposed, and they've taken the view that those gaps need to be filled. The cost of living crisis has also resulted, it seems to be, in intensified scrutiny on the lowest paid in society and those who are working unpredictable shift patterns. I think this legislation has gone a little bit too far in that it doesn't properly recognise that a lot of workers want to continue working flexibly. And it also demonstrates, in my view, a rather outdated view of what the employment landscape should look like. I think the Labour Party has historically suffered from a view, which I think is now very outdated, that you are only in proper employment if you're working for 35, 38, 40 hours a week, 5 days a week. Anything that doesn't look like that, in the Labour Party's view, isn't proper employment. And I think that philosophical position has resulted in some of the provisions that we see in the bill, specifically around unpredictable shift patterns, 0 hours contracts, and guaranteed hours. We've seen a lot of high-profile cases over the last few years in relation to various underpayments to workers, abuse of working time rules, sham contracts, so people set up as self-employed when in reality they're employees or they're workers, and therefore they're not being afforded the rights that they should have. And those high-profile cases, I think, have placed the government under some pressure to try to do something about what the labour supply chain looks like, and more particularly how it operates. This touches on the last point I made. I think the provisions are signalling a shift from employer flexibility, which has very much been the order of the day, to worker security. So we're moving from employers holding all the cards to workers holding more of the cards and having a much more secure future. But the big thing that misses is the need for employer flexibility and the desire for workers to have flexible arrangements because of everything else that life has to throw at people. So what this bill marks really is the start of a much longer term agenda to strengthen worker protections and regulate agencies and umbrellas more tightly. You might remember when the bill was published in late 2024, there was another document published at the same time, because as employment lawyers, we read the bill and we realised that there was a lot that wasn't in the bill that government had promised during the election campaign. That document was called Next Steps. So bear in mind that none of the provisions in the bill deal with anything in the Next Steps document. Next Steps is, as it says, next steps. So once this bill is in, at the appropriate point, and the government have always suggested that it will be before the end of this Parliament, at the appropriate point, they intend to legislate further on these next step issues. The big one for this sector is likely to be single worker status, where we potentially might see the abolition of the distinction between workers and employees, and workers' rights enhanced to bring them up to a level, up to par with employee rights. So this employment rights bill is not the end of this government's intentions around worker security and increased employment rights for workers. Far from it. It really is just the start. Okay, can we move on to the next slide? In fact, we might need to skip this one and move on to the next one, Catherine. Thank you. So when people say to me, well, what do we need to do now, Paul? The short answer to that question is, well, it's difficult to say because nothing's happened yet. All we've got is a bill, and the bill has changed in complexion, substance, and content since it was published late last year. So it will be wrong to start putting in place immediate changes, for example, to contracts of employment, to policies and procedures. But it is important to make sure that you keep abreast of things as they develop, because I don't think it's going to be too long before we start saying to people, you are going to have to change the way you operate. If you're in the umbrella sector, for example, or you're using umbrellas, the change to the tax arrangements in April next year are already prompting changes to terms and conditions, reviews of supplier engagements, compliance, and all the rest of it. People are becoming much more aware of that. But as regards the bill, the Employment Rights Bill itself, it is a little premature to start making changes, but it is not too premature to start considering in detail what the changes might look like and how you may need to respond to those. And of course, as a firm of lawyers where we're keeping up to speed and abreast of all of these changes, we're going to be in a very good position to help give you that sort of advice moving forward. But there's no doubt we're going to see more tribunal claims. So if you get all of this wrong or any of it wrong, you're likely to be sued, even though the tribunal system at the moment is probably not fit for purpose. There's likely to be some reputational damage as a result of some of these claims, especially if they're brought by multiple workers. So you're getting the same thing wrong each time, and you're regularly in front of the employment tribunal. Spare a thought for your HR people and the HR people that your clients engage. They're going to have a lot of additional administrative tasks to undertake, a lot of additional data to keep an eye on, a lot of time limits to diarise. So there may be more HR people required, but if more people aren't recruited, I suspect there may be an element of HR burnout, not to mention managerial meltdown. So one of the things that we're very good at here at JMW is going into businesses and training managers, because managers are at the front line. They very often are the ones who spot, or in some circumstances don't spot, the problem that arises. So they need to be armed with all of the appropriate information, so that if a situation arises that they know might turn litigious, they can deal with it. So employers are going to need to keep a very careful eye on developments and test whether there's any action required. Next slide, please, Catherine. So where are we going to see significant impact? Well, no doubt in payroll and finance. The umbrella changes in April next year are going to see a lot of additional pressure on those functions. Agencies are going to be jointly and severally liable. There are going to be more rights, which are going to result in more payments due, and that function, I think, is going to be stretched. Diarising deadlines around contracts and scheduling. If we do have a 12-week reference period in relation to 0 hours contracts and the offer of a guaranteed hours contract, then someone's going to have to make sure there's a system in place to track that 12 weeks. Someone's going to have a system in place to ensure that the correct guaranteed hours offers are being made. And someone's going to have in place proper, robust systems to ensure that if there are shift cancellations or if there are modifications to shifts, that reasonable notice is given of both of them. So a lot of additional admin tasks there. I think that flows into the next bullet point, which is a point I've already made around HR and people management. A lot more responsibility for the teams who are responsible for that. And importantly, this will have a big impact on client relationships. So it's very important, I think, for agencies working with clients to get close to clients, to help take them through this process of change as best they can. And my own personal view is if you do that, you've got the best chance of being given preference over an agency that either didn't seem to care or didn't really know what it was doing. There may have to be some adjustments, of course, to pricing models as a result of these extra burdens, but it's a little bit difficult to say at the moment exactly what that might look like. So there are the areas where I think the most sort of day-to-day impact is going to be felt. Let's move on and talk very briefly then about umbrella regulations. And the next slide. Excellent, thanks, Catherine. So some of these figures, some of these provisions may not be known to you, but apparently there are around 700,000 umbrella workers supplied at any one time in the UK, and about 500 umbrella companies. The government's stated aim is to make sure that people that work through umbrellas have got comparable rights and protections to their counterparts who work directly through an employment business. So there's a requirement here in the government's mind to ensure a level playing field. So the bill's going to allow for the regulation of umbrellas and state enforcement of that regulation as there is currently by the Employment Agency Standards Inspectorate, which, as I've said, will then become part of the Fair Work Agency. And the way that the government are going to do that, they're going to achieve that regulatory framework, is by expanding the legal definition of employment business to include umbrella companies. That will be subject to consultation, but we've got a rough and ready idea as to how they're going to go about that. Not an enormous change in terms of the legislative wording, but quite a big change then for umbrellas to make sure that they are compliant with the Employment Agencies Act and the conduct regulations. Okay, next slide, please. So what that will do, and I should make the point in case anyone's not sure, umbrella workers supplied to agencies are currently already covered by the agency workers regulations. So they're entitled to equal treatment after the appropriate qualifying period. This won't change any of that, but what this will do is ensure comparable treatment from a regulatory perspective for any worker supplied through an umbrella to an agency, because the umbrella at the moment isn't subject to that regulatory framework, but will once these new provisions are amended after consultation. Okay, next slide. Now, I'm not a tax expert, but I didn't think I could talk about umbrella regulation without talking about the finance bill. And to some extent, I'm repeating what I've already said. But I'll just go through it now in a little bit more detail. So the 21st of July, the government published some draft legislation that, if it's enacted, and there's every chance it will be, it will represent a significant change in their overall approach to non-compliance within the umbrella sector. And it stems from high-profile cases where umbrellas have not accounted to the revenue for tax and national insurance that they should have accounted to the revenue for, and which they've had already from the agency. So we've got consultation on the draft legislation, and we're expecting the bill, the finance bill, to be passed in early 2026. It contains a lot of other provisions apart from this, by the way. I'm only focusing on the umbrella provision. But the draft bill sets out the concept of joint and several liability. What that effectively means is that from April 2026, HMRC will be able to go and pursue umbrella companies as well as the agencies that they supply, and potentially end clients where there's unpaid PAYE if the umbrella hasn't accounted properly. So where the umbrella fails to account and the revenue are out of pocket, then they will be able to pursue the agency, and in some circumstances they'll be able to pursue the end user client. So that's a huge change to the way in which umbrellas and agencies interact and do business. So we're moving to the next slide, please, Catherine. Now, I think the watchword in the new regime from April of next year is going to be due diligence. I've been saying for a long time that agencies should should take note of how the umbrellas that they work with do business, and that they should properly scrutinise the nature of the relationship between the umbrella and the worker, and they should look at the way in which monies which they pay over to the umbrella are being handled, dealt with, and hopefully paid over to the revenue. So there is going to have to be much more transparency about the nature of the umbrella supply chain. And that is largely going to be driven by agencies who will, from April 2026, be in the firing line if the umbrella doesn't properly account. So a lot more due diligence than currently takes place is going to have to happen, because that lack of due diligence will then expose the agency to that joint and several liability for unpaid tax and NICs. Okay, next slide, please. So, what should the strategy be? Where can we future-proof? Just a few suggestions on the next slide. Well, there are some proactive measures that agencies can take. They should be conducting regular audits of their umbrella providers, and they should be using accredited umbrellas. FCSA is one such trade body or accreditation organisation that requires its members to be regularly audited. And if you're using an umbrella, you may want to think very carefully about using an umbrella that is FCSA accredited. Given the tax changes and the fact that there are likely to be end user clients potentially on the hook, it's very important to make sure clients are educated about these changes. And you'd be amazed how many end user clients currently don't understand what's happening at the other end of the supply chain. They may be completely oblivious to the fact that an umbrella company is being used and that the workers who are being supplied are umbrella employees. But this is not just about the changes to the tax system when it comes to umbrellas. I've already banged the drum several times during this conversation about educating clients, candidates, workers about the Employment Rights Bill and the implications of it. It's all about building trust, clear communication, the demonstration of ethical practices, and having very transparent pay and benefit structures in place so that everyone can see where and how the money is moving. And I think there's every possibility that if you embrace these changes, not only around umbrellas, but also around the ERB, you've got every chance of achieving a strategic commercial advantage when it comes to your competitors. You'll be positioning compliance as a selling point. You will be demonstrably showing clients that you're reducing their risk and exposure. And this is important, you'll be attracting quality candidates because you are dealing with them, with the clients and the umbrellas in a very fair and reasonable fashion. And I think I can move on to my final slide, Catherine. What are the key takeaways? Well, as I've said, nothing to do at the moment, but you must stay alert. I'm a lawyer who specialises in this area, so I would say, wouldn't I, that you should seek legal advice. I'm saying that more than I've ever said it before because, as you'll know, I'm a fairly prolific user of LinkedIn, and some of the nonsense that I have seen on LinkedIn about what the Employment Rights Bill says is frightening. If you are taking your advice from social media on the Employment Rights Bill and the changes to umbrellas, then you really do need to think again. That is an exceptionally risky strategy. And because there's reputational risk involved in all of this, as well as financial risk with an increase in employment tribunal claims, damages and compensation, you really do need to act appropriately to make sure your brand, which you work long and hard for, is protected and that you don't fall foul of these provisions. that, I think, is me done. I've left us with a few minutes for questions, so I'm very happy to hand back to Simon. Thanks, Simon.
Thank you, Paul. And I'm just going to whiz through some of the key ones here. Here we go. Jane Storer put up the first question seconds after we started. If we officially end an assignment at 13 weeks and then ask the temp worker to take a week's holiday, would the calendar start again to avoid the need for a perm offer?
Yeah. Now, my gut feel to that, or my gut answer to that is that's avoidance. Yeah. And I think what we're going to end up with is a very similar type of anti-avoidance regime to the one that we had when the agency workers regulations came in. Jane, you might remember that there were some provisions brought in to make sure that you couldn't manufacture assignments in such a way as to avoid the worker getting the qualifying period. I think we're going to be in similar territory with this, because otherwise it would just be too easy and people would never get the right to receive a guaranteed hours contract offer. But I can't say for certain, because a lot of this will depend on consultation and regulations which are yet to be published.
Yeah, thank you. Lee White said, does guaranteed hours mean a permanent contract?
Yeah, another good question. And you're not going to thank me for saying to you, I don't know. There is some suggestion that different types of contract will be legitimate under these provisions. But when you say permanent contract, effectively what you mean is a contract that's terminable on notice. I think there's limited scope for fixed term contracts to be appropriate solutions in these circumstances. So I do think the default position is probably going to be a permanent contract, but a permanent contract, as you know, is terminable on appropriate statutory minimum notice.
Cool. A LinkedIn user who joined us said, statutory sick pay, what is the removal of the lower earnings limit, which brings in, as you said, I think 1.3 million more.
Yeah. So I'd forgive me for not having the precise figure, but from memory, I think the lower earnings limit is around about 120, 130 pounds. Anyone that earns less than that currently doesn't have any entitlement to statutory sick pay, and that's about 1.3 million workers. The government has said that they intend to abolish that, which will mean that everybody that earns less than the lower earnings limit will then be entitled to statutory sick pay as long as they satisfy all of the other qualifying criteria.
Mondays could be a tricky day, couldn't it, with statutory sick pay?
It could.
On day one. Okay. Kalpesh, thank you for joining us. Kalpesh Baxsi's thrown a couple of questions in. Does this mean we expect a change in the intermediary reporting?
That's probably beyond my pay grade, Kalpesh, because that's more of a sort of tax HMRC question, and it's not my area of expertise, but I ought to be able to find out for you. So if you leave that with me, I will do my best to get an answer to that.
Never want to keep quiet with Kalpesh. He's asked another question. If there's one thing, I think you've answered this actually. He did say if there's one thing recruitment owners can do to prepare themselves today for the ERB and the UCR, what would you say? I think the previous couple of slides said, and I was going to say you took away some of my thunder. You need to get behind this. This is going to be the same for every recruitment company. A lot of our clients don't know this is coming, especially in the SME space. Like the smaller business owners, they are learning more about this, maybe not as fast as we are because of these webinars that the industry is running. So if you get behind these, listen to more webinars like Paul's given today, understand it and run some roundtables or sessions yourselves. With an employment lawyer. Other employment lawyers are available, but you're going to build a lot of trust with some of your SME clients who don't really know this is coming down the track. So I definitely get behind it. Stay tuned to this. We're going to do another one or two of these, aren't we, Paul? As consultation concludes and there's more clarity in what's coming down the track, we'll run a couple more sessions. Once we've done those, that's a great time to start to run your own sessions with your existing clients and target clients to really build some trust with them and educate them about what's happening and what those changes are for. I've got another question from Kester Somerville Ford. We often place umbrella contractors. Are there any specific terms we need to update with our end clients? Well, yes, there will be.
Yeah, I think that's right. I mean, certainly end user clients, if they're not aware of the tax changes proposed in April, will need to be aware of them. And that might result in you agreeing a slightly different commercial arrangement with them, either because they seek to impose it on you or you suggest it's to your benefit if you do. So I think the short answer to that is a lot of what I've talked about today will ultimately result in those contractual arrangements having to be reviewed at least.
Cool. Well, Paul, thank you very much for a pretty intensive hour with lots of great overview of where we're going, timescales, and what might change. But we'll watch this space. We'll get you back once there's more clarity in what's happening after consultation. If anyone wants more information and to connect directly with Paul, there's details on the slide now. Paul, thank you very much for the support you've given us today, team members, and the recruitment market overall. JMW have been brilliant at supporting us from
You're very welcome.
Our industry for many years. Cool.
You're very welcome. Thanks,
Good.
Simon.
Cheers now, everyone. Thank you.
Bye-bye.